social media check-in.
All right, our first question comes from Roberlin on YouTube asking, are there any new updates for F2B categories?
What are the new updates? We go to Visa Bulletin, and in Visa Bulletin, and the update is they are processing outside of the United States July 8th, 2015, except there's a pandemic proclamation, so nobody's really allowed to come outside of the United States. Inside the United States, they're also processing July 18th, 2015. If you're eligible to adjust here, you would get your green card.
The next one comes from Vivian's. What happens to my application if my spouse dies?
That's the end of the application as well. If your spouse filed for you, though, it converts automatically from a spousal petition to a widow petition, and then you complete the case as a widower.
Muhammad Abu on YouTube asks, I had an e-felony 4th degree conspiracy before 11 years ago in the U.S., and I got deported 11 years ago. My love of my life came to Jordan. We got married before 2 years ago, and she is with me in my home country. Do you think that my felony will hurt me for applying for a green card?
It depends what the felony's for. Did he tell us what the felony is for?
Just said an e-felony 4th degree conspiracy.
Conspiracy to distribute drugs, you are never coming back to America again.
Oh,
sorry.
whoa.
Unless they change the law. I don't see anybody changing the law anytime soon where the government says, okay, if you got deported for conspiracy to distribute drugs, you can come back. Yeah.
SJ on YouTube, my expedited process at NVC for EB3 nurse is under review for about a month now. Is it due to the embassy not responding to NVC, or NVC itself is taking time to review the case?
I don't know what the problem is with your particular case, but you could have a consultation with me and we can figure it out.
Okay, Saifi Darbo on YouTube asks, how long does it take after an interview to get your green card if the case was approved on the spot?
About 8 weeks.
Singleton Leonard on YouTube, I'm currently having an I-360 pending, and now I'm about to get married. What should I do to get my case stopped so I can file as married?
You have an I-360 pending, so there's a VAWA case pending, and you're going to give up that VAWA case, and now you're going to get married and do an adjustment. You're going to withdraw the VAWA and file a new adjustment based on your marriage.
Lasha Bernades on Facebook asks, my I-130 case petition for an undocumented relative is still pending from the end of August 2019. There's been no response from immigration. Is this normal?
What's been pending since 2019?
The I-130 case petition for an undocumented relative.
I don't know who the relative is. It could be a brother, sister. It could take 10 years. That could be normal. If it's your husband, it could be, you know, also normal. It's not unheard of, but 2019 is a long time for a spouse, not necessarily for a brother, sister. So who's the relative?
We don't know. Okay, next one comes from Max Taylor on YouTube. Can a green card holder file for an extension to get a work permit for a child who is over 21 and is here in the U.S. and still in status? Time finished in January.
What do they want to do?
Can a green card holder file for an extension to get a work permit for a child who is over 21 and is here in the U.S. and is still in status?
A green card holder can sponsor a child, but you're on a waiting list for 5-6 years. You can't file, not an extension, I guess an adjustment. You can't file an adjustment immediately for a child over the age of 21 unless you have an approved I-130 and the priority date is current. Then the answer is yes. But I think the question that they're asking is, there's a green card holder and his child or her child is over 21 and in the United States and is in legal status. Can I adjust their status? The answer is no, unless you have the approved I-130 and that priority date is current. As I said, the priority dates are up to July 8th, 2015.
All right, Mario Navis on Facebook asks, my mom married a U.S. citizen in 1998. He filed an I-130 petition for her, but he ended up divorcing her before the I-130 was approved. Can she claim Section 245I to AOS her EB3?
When was this first application filed?
1998. Or no, the mom married the U.S. citizen in 1998. So he filed the I-130 petition for her. It must have been like right after.
Okay. If she was physically here on December 21st, 2000, the answer is yes.
Oh, okay.
Zargoza Fam on Facebook. My husband petitioned my 3 kids in the Philippines. The petition was approved last month and it was now transferred to NBC, but my youngest daughter still needs evidence because her birth certificate was registered late and we are waiting for DNA. Do I have to wait for her approval before I go on to NBC?
Yes.
Okay, Sean Hicks on Facebook asked, my wife's case arrived here on a visitor's visa and overstayed. Applied for asylum back in 2004, it was denied. Appealed in 2005, and it was granted voluntary departure in absentia, which is now an automatic deportation order. She also has a misrepresentation of a material fact in her immigration file. We haven't approved I-130. Our attorney said she'll need a waiver for the misrepresentation. We have to file a motion to reopen her case. We have a 3-year-old daughter who is my heart and a young man who is about to turn 7 years old, my baby boy. If something were to happen to me before a motion to reopen was granted, can my wife file under case law 204L?
If something were to happen to you, you were to die. That's 204L is dying. She would still need to reopen her deportation case. And if it's an in absentia order, that means she didn't show up. The way to reopen the deportation case is prove you didn't get proper notice. Assuming that the case is reopened for not proper notice, and God forbid you were to pass away, under Section 204L, your wife would be eligible to adjust her status and show hardship to herself for the waiver. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.